Jury selection will begin today in the legal battle between 29 states and Meta, the parent company of Facebook and Instagram. A coalition of state attorneys general are claiming Meta's platforms were designed to deliberately keep kids addicted and that the company misled the public about their safety. Meta has strongly denied the allegations and says the company is committed to supporting young people. Let's bring in CBS News contributor Jessica Levinson. So, Jessica, this is widely considered the biggest legal challenge yet for social media companies when it comes to younger users. Break down the case for us.
So largely what you said, which is that these states are arguing that Meta knew it was designing a product that was addictive, that it lied about it, and that it essentially understood that there could be mental health harms that resulted from the way they designed this platform. There are also allegations in here that they took children's online information in violation of federal privacy laws. So it's really two parts. You designed a product that you knew was problematic, and you took information that you should have known that you couldn't under federal law.
I mean, I'm so curious about this case because even for adults, like these platforms are addictive. You reach for your phone and open Instagram before you even realize what you're doing.
Yep.
This case is proceeding after a landmark ruling from the Ninth Circuit Court on Monday. Tell us about what happened there and what that means for future cases like this one.
Well, and I think your question brings up a really important point, which is many of us know this is addictive. And so part of what will happen in the trial, and I'll get to the Ninth Circuit, but part of what will happen is that Meta will say there is individual responsibility here, that parents need to say to kids, I'm limiting your time, that's not on Meta to limit their time, that adults and children need to say, I know that this is a product that's designed to keep me entertained, that's designed to keep me on there. That's the business plan. I need to take it upon myself to stop. It's not on them to change their design to make it less effective. Now, to your question about the Ninth Circuit, what they ruled in a similar case was against Meta and other social media companies on Monday. They had made the argument that under a federal law, Section 230, that they could not be sued in this case, that the case could not continue because Section 230 protects social media companies based on things that are written on their platforms. For instance, if you want to post on X or on Instagram or on Facebook, Jessica Levinson, and then fill in the blank, is a criminal, has this loathsome disease. I can't sue Facebook, but I can sue you. The federal judges on Monday said that is just a bar to liability. It's not a bar to immunity, which is all a way of saying the Ninth Circuit cleared the way for this case, which is expected to last about 7 weeks, to continue.
Wow.
Liability versus immunity, meaning they can't be held liable, but they're not completely immune, and they can still be charged or they can still be held criminally accountable?
Exactly. This is a civil case, and that difference between liability and immunity is difficult. What I'll also say is that much of the theory of this case is not based on necessarily the content of what is actually posted on social media, but increasingly what we saw when I think we all got to talk about the New Mexico case where there was a favorable ruling for plaintiffs recently, what we're increasingly seeing is plaintiffs, including the state attorney generals, are making the argument that we're not complaining about what's posted, we're complaining about the design and how what's posted is provided to people. So that's another way that plaintiffs are trying to get around that liability, not immunity bar in Section 230.
So if Meta loses this case, they could have to pay damages like in the New Mexico case that could potentially go toward some kind of programming to help young people, or could it even could they have to change their design potentially?
So in part of the case is monetary damages, and the estimates are that this could include over $1 trillion, I think $1.4 trillion in damages. But to your point, or to your question, the other part of this case is about basically change what you're doing. So things like the infinite scroll that allow, I'm a victim of this too, that allow me to just keep scrolling. I need to force myself to stop. There's no limit on the amount of time that children can spend on these social media platforms. So basically what the states are asking for is not just money, but change your design, make it less addictive, and they're arguing less dangerous for children.
We will be following this. Jessica, thank you so
Thanks,
much for
Jessica.
explaining it so clearly.